Barangay San Roque v. Heirs of Pastor. Fax petitioner filed before the MTC of Talisay, Cebu a complaint to expropriate a property of the respondents. In an order, the MTC dismissed the complaint on the ground of lack of jurisdiction. It reasoned that eminent domain is an exercise of the power to take private property for public use. After payment of just compensation. In an action for eminent domain, therefore, the principal cause of action is the exercise of such power or right. The fact that the action also involves real property is merely incidental. An action for eminent domain is therefore within the exclusive original jurisdiction of the regional trial court and not with this court. On appeal, the RDC dismissed the complaint, holding that an action for eminent domain affected title to real property, hence, the value of the property to be expropriated would determine whether the case should be filed before the MTC or the RDC. The RDC concluded that the action should have been filed before the MTC since the value of the subject property was less than P20,000. Aggrieved, petitioner appealed directly to this court, raising a pure question of law. Respondents contend that the complaint for eminent domain affects the title to or possession of real property. Thus, they argue that the case should have been brought before the MTC, pursuant to BP 129 as amended by Section 3 of RA 7691. This law provides that MTCs shall have exclusive original jurisdiction over all civil actions that involve title to or possession of real property, the assessed value of which does not exceed 20,000 pesos or, in civil actions in Metro Manila, 50,000 pesos exclusive of interest, damages of whatever kind, attorney's fees, litigation expenses and costs. Issue 1. An expropriation suit is one incapable of pecuniary estimation and is therefore within the jurisdiction of the RDC. Held yes. Ratio A review of the jurisprudence of this court indicates that in determining whether an action is one the subject matter of which is not capable of pecuniary estimation. This court has adopted the criterion of first ascertaining the nature of the principal action or remedy sought. If it is primarily for the recovery of a sum of money, the claim is considered capable of pecuniary estimation, and whether jurisdiction is in the municipal courts or in the courts of first instance would depend on the amount of the claim. However, where the basic issue is something other than the right to recover a sum of money, or where the money claim is purely incidental to, or a consequence of, the principal relief sought. Like in suits to have the defendant perform his part of the contract and in actions for support, or for annulment of a judgment or to foreclose a mortgage. This court has considered such actions as cases where the subject of the litigation may not be estimated in terms of money, and are cognizable exclusively by courts of first instance. The rationale of the rule is plainly that the second-class cases, besides the determination of damages, demand an inquiry into other factors which the law has deemed to be more within the competence of courts of first instance, which were the lowest courts of record at the time that the first organic laws of the judiciary were enacted allocating jurisdiction. In the present case, an expropriation suit does not involve the recovery of a sum of money. Rather, it deals with the exercise by the government of its authority and right to take private property for public use. In National Power Corporation v. Jaclyn, the court ruled that expropriation proceedings have two phases. The first is concerned with the determination of the authority of the plaintiff to exercise the power of eminent domain and the propriety of its exercise in the context of the facts involved in the suit. It ends with an order, if not of dismissal of the action, of condemnation declaring that the plaintiff has a lawful right to take the property sought to be condemned, for the public use or purpose described in the complaint. Upon the payment of just compensation to be determined as of the date of the filing of the complaint, an order of dismissal, if this be ordained, would be a final one, of course, since it finally disposes of the action and leaves nothing more to be done by the court on the merits. So, too, would an order of condemnation be a final one, for thereafter, as the rules expressly state, in the proceedings before the trial court, No objection to the exercise of the right of condemnation shall be filed or heard. The second phase of the eminent domain action is concerned with the determination by the court of the just compensation for the property sought to be taken. This is done by the court with the assistance of not more than 3 commissioners. The order fixing the just compensation on the basis of the evidence before, and findings of, the commissioners would be final. 2. It would finally dispose of the second stage of the suit, and leave nothing more to be done by the court regarding the issue. It should be stressed that the primary consideration in an expropriation suit is whether the government or any of its instrumentalities has complied with the requisites for the taking of private property. Hence, the courts determine the authority of the government entity, the necessity of the expropriation, and the observance of due process. In the main, the subject of an expropriation suit is the government's exercise of eminent domain, a matter that is incapable of pecuniary estimation. True, the value of the property to be expropriated is estimated in monetary terms, for the court is duty-bound to determine the just compensation for it. This, however, is merely incidental to the expropriation suit. Indeed, that amount is determined only after the court is satisfied with the propriety of the expropriation. Verily, the court held in Republic of the Philippines v. Zerbino that condemnation proceedings are within the jurisdiction of courts of first instance, the forerunners of the regional trial courts. The said case was decided during the effectivity of the Judiciary Act of 1948 which, like BP 129 in respect to RTCs, provided that courts of first instance had original jurisdiction over all civil actions in which the subject of the litigation is not capable of pecuniary estimation. The 1997 amendments to the Rules of Court were not intended to change these jurisprudential precedents. We are not persuaded by respondents' argument that the present action involves the title to or possession of a parcel of land. They cite the observation of retired Justice Jose Y. Faria, an eminent authority in remedial law, that condemnation or expropriation proceedings are examples of real actions that affect the title to or possession of a parcel of land. Their reliance is misplaced. Justice Faria sought merely to distinguish between real and personal actions. His discussion on this point pertained to the nature of actions, not to the jurisdiction of courts. In fact, in his pre-bar lectures, he emphasizes that jurisdiction over eminent domain cases is still within the RTCs under the 1997 rules. To emphasize, the question in the present suit is whether the government may expropriate private property under the given set of circumstances. The government does not dispute respondents' title to or possession of the same. Indeed, it is not a question of who has a better title or right, for the government does not even claim that it has a title to the property. It merely asserts its inherent sovereign power to appropriate and control individual property for the public benefit, as the public necessity, convenience, or welfare may demand.